Hello, I'm Janice Karen, Director of Policy, Technology, and Innovation at the Massachusetts Health Data Consortium, or MHDC. I run our Data Governance Collaborative, also known as the DGC. We start each of our weekly meetings with a series of industry quick updates to learn about new and proposed regulations, laws, standards, industry initiatives, and other activity. Join us for this week's updates. If you'll move to the first update, please. Are you able to move forward? Thank you. So last Wednesday, HHS, Office of Civil Rights, which is the group that oversees HIPAA, put out a notice of proposed rulemaking on HIPAA privacy around reproductive health data. It not have a chance to check, but it supposedly went out in the Federal Register on Monday. Comments will be accepted through June 19th. That date was not listed anywhere. We were counting out the proper number of days, so that may be approximate. So what does this rule do? It puts in some specific rules around sharing reproductive health data for administrative or judicial proceedings or other types of investigatory things. So you are not allowed to disclose PHI to any investigation that's related to seeking, obtaining, providing, or facilitating reproductive health care that was legally provided. What does that mean? That's, of course, the thorny issue. You are also not allowed to disclose PHI for the purpose of helping people identify who they should target for investigation. So they give some examples of when healthcare is legal, but that have come up where some people might still want to investigate or cause problems. So one of those examples is data around reproductive health care when someone travels from a state where that care is illegal to a state where it is legal. If it's legal where the care was provided, then it was legally provided and it falls under this rule. Also, any healthcare data that is protected by federal law, and they give an example around miscarriage management to stabilize the health of a pregnant person. So basically, there's a law that says you must provide medically necessary care, and they're using that law to say that you can't inhibit you can't therefore miscarriage management when the health of the mother is in doubt is perfectly legal regardless of what other people might say about it, and therefore you can't collect data around it. So the way that they're doing this is for any agency that may have both legal and not legal around this framework requests for PHI, they have to sign an attestation that the rules are being followed before the data can be released. So if for any health, what they list 4 areas: health oversight activities, which is the nebulous one, judicial or administrative proceedings, law enforcement or coroners and medical examiners. So if anything that falls under those 4 categories, before you're allowed to release any PHI to one of those organizations, or for the case of health oversight activities, whoever's performing those activities, that the person requesting the data has to sign an attestation that they are not using the data for any of these prohibited purposes. And you must have that signed attestation before you send them any data. So I have not read the full rule. That's from an overview. We will definitely look at that a little bit closer. Initially, it made it sound like you needed that attestation. The first thing that I saw made it sound like you needed that attestation for any data exchange, and I thought that was going to be interesting. That was going to be interesting, but it appears like it's specific to these cases. But that's still something that probably requires manual intervention and is going to be interesting. So you can find a fact sheet from HHS and the proposed rule at the links provided. Any questions or comments so far?
Yeah, question. Does the definition of data include in printed form?
Include what? I'm sorry?
In printed form?
I assume so, yes. This did not appear to be electronic in nature. They didn't say, for instance, EHI or EPHI or anything like that.
Hey Janice, this is Melissa. I was just curious,
Hey.
Do the same rules that apply like to medical providers get passed along? So the same consequences of violating HIPAA, do those get passed along to those who'd be signing these agreements? Do you happen to know anything about that?
I don't know what the consequences are for the
Okay.
people who sign these attestations and then violate them. I hope there's something about that in the full proposed rule, which I have not had a chance to read yet.
Gotcha. Thank you.
So we'll follow up on that if more information is outlined.
Hey, Janice, it's Lee.
Hey, Lee.
Happy Wednesday. Quick question.
Thank
you. I'm presuming the opposed applicability of this when it becomes law is all HIPAA covered entities, not any certain populations. Is that correct?
That's correct.
Okay. Interesting. Thank you.
Yep. And like I said, I didn't, there was a little bit of conflicting information out there, but I believe that what I have on here is correct. This was the general consensus. But if there are any changes or anything else that becomes apparent when I read the actual rule, I'll definitely follow up.
All right. Thank you.
Yep. Any other comments or thoughts? All right, then let's.
Just a comment.
Oh, sure.
Hi, this is Terry Anderson. Just a comment. As I was reading this, it reminded me so much of 42 CFR Part 2 that was designed to protect substance use treatment records way back when. It sounds like they're taking HIPAA down that path. Just a comment.
Yeah, that's very possible. It's really not clear to me yet exactly where this is going, but we'll have to see. Well, thank you for the comments. Let's go ahead and move on to the next item, which is related. So on the same day that the rule came out, ONC posted a blog post on information blocking and HIPAA. Sort of what are the consequences of this for information blocking? They also added some new fact entries that were related. So one of the things, they just sort of, not all of this was specific to the new rules. So it was kind of like, let's take this as an opportunity to remind folks about how HIPAA and information blocking interplay with each other, and just in general, how privacy laws and information blocking work. So some key things to remember that they pointed out in the blog post is that if a law prohibits the sharing of data, then don't share it, and that is not information blocking. So if HIPAA says no, no is fine. So, and they give us an example, disclosing genetic information for insurance underwriting purposes. That is explicitly prohibited by HIPAA, and that is perfect. If you get a request to do that, you should say no. And then you can use there's a legal, one of the 8 exceptions is around legal purposes. So you can use that exception and then you're fine. But also, if another law requires that specific requirements are met first, then not sharing the data when the requirements are not met is not information blocking. So this would be a case where the new law comes in. So if you get a request for reproductive health care data from an entity that may be falling into one of these categories, then not sharing until you get a signed attestation is not information blocking, because you're required to get that signed attestation before you share. And none of these rules outline specific laws or specific cases that are covered. They are written generally so that any law applies, so that as laws change, the information blocking rules adjust to accommodate what the new laws say. So you can find the full blog post at the link, and that blog post also has links to the 3 new FAQ entries that cover, I think it was 3, that cover some of these topics. So any questions or comments there? All right, then let's go on to the other ONC blog post. So this one we have, this one is on transparency and trustworthiness in AI, which, as everyone knows, is a hot topic. So this blog post provides some background information, and then it talks about some of the related requirements in the new ONC proposed rule around the clinical decision support requirements for certification. That you may remember, we went over this last week. The HTI-1 is the designation they've given for that rule. And so what they basically say is that any certified health IT that interfaces with any type of predictive AI must provide users information on 4 things: the development of the AI, an evaluation of its validity, information about fairness and effectiveness, and then information on ongoing monitoring and use. And that last part has to be both technical and performance related. So basically, if you're going to include AI in anything that you provide or anything that you use, you need to provide a whole bunch more information than you have in the past about the AI, from the start of its development through ongoing use, and basically evaluate how it's working so that the people who are using it can make a decision about whether they want to continue using that model or not. In order to do this, there's a new acronym called FAVES, and this is sort of to encapsulate the goals. So FAVES stands for fair, appropriate, valid, effective, and safe. And they make a point when they introduce FAVES to say that there are other important areas. They didn't include the acronym because they liked the acronym, but they specifically point out being reliable and being secure. And they basically say that FAVES is meant to encapsulate everything that should be required for a trustworthy or high quality algorithm. They kind of equate trustworthy and high quality within the blog. Any questions so far? There's another slide on this, which is why there's no link yet. All right, let's go on to the next slide. So some of the specific things that they talk about, excuse me, are that developers of AI have to perform, document, and publish information specifically on intervention risk management. And they point to a new NIST AI risk management framework, which we'll be talking about on the next slide, as to how they came up with this. And they talk about different types of risks around validity and reliability, privacy, and security. In addition, developers have to document and publish information on governance and data management. So this is around things like allowing users to evaluate the ground truth data that's used when developing an algorithm or a model, so that they can determine whether it's appropriate for their specific use cases. So if all of the data that goes into a particular AI algorithm was developed from, let's say, University of Chicago Medical Center, then at the main hospital in the south side of Chicago, then that model may not be appropriate for a population that is primarily rural and primarily white in the middle of Idaho or something. And that's up to the people. So what this says is that you have to document that the model was developed under these circumstances so that the people in the other places can say, well, I don't have the trust in this model being appropriate for my population. And in addition to that, you have to look at, the quality of the data, where the data came from, again, how representative it is, like we were just talking about. And so the idea here is transparency so that people can evaluate whether or not the specific model in question is appropriate for them. So there's a link there to the post. It was a really interesting read. Any questions or comments?
Well, this looking at the ground truth data and so on, that works in sort of narrow applications where you have very specific identifiable data sets underneath. So if you're looking at an AI application that's based on one of these large language models, that's more or less impossible, isn't it?
Well, there are some AI models that are somewhat abstracted from their original definition. Certainly, almost anything that has a machine learning component at its heart, at some point at least, started from some ground truth data and then got evaluated from there. I mean, that's just the way that type of AI works. But there are other types of AI. So I'm the one, I will say, I pulled out the idea of ground truth data as an illustrative example. It's not specific to that. So if there's another, if you are using a model where there's some other mechanism in play, then the idea is all of the equivalent data governance and data management practices have to be documented and published. But for 95 or 99% or some very high percentage of the stuff that we talk about or that we look at, it's the core of where things start is going to be some type of ground truth data. There's a lot of other components too, but that's really where it all starts from. Any other comments or thoughts? All right, let's move on. So I mentioned this a moment ago. Excuse me. Not sure exactly when this came out, but it was mentioned in the ONC blog piece we were just looking at. But NIST has an AI risk management framework that basically has 6 major sections with some appendixes that talk about other stuff. So the major areas are framing the risk, which talks about how to describe risks, looks at impacts and harms addressed. It talks about audience, which as a longtime technical writer, I approve. That's the key of knowing what to look at, knowing your audience. So that describes the roles that are involved in AI and the AI lifecycle and a little bit about how to think about them. Then they talk about risks and trustworthiness, how to define the characteristics of what a trustworthy AI is within the framework and how to evaluate them. Effectiveness, which is the expected benefits from using the framework. And then the core of it, the last 2 sections are the risk management framework core, which is basically 4 categories of things to look at, which is governance, mapping, measuring, and managing. So they go into, I did not have a chance to look in detail yet at what they talk about in each of those sections, but basically those are the specific principles that you should be looking at when you're using this framework. And then the profiles, the way that all of these frameworks are set up is that the core applies to everything, and then profiles are some additional criteria that are industry specific or specific to particular settings. So that's the last area. And then inside the appendixes, there's a couple of others, but the two that I thought were really interesting were a discussion about how risk in AI is different from other types of software risks, and then a discussion of human and AI interaction. So you can find the starting point for the framework at that link, and it's definitely worth looking at more. I will do so as well. And any questions or thoughts?
Janice, it's Denny. Would it be fair to say that these kinds of frameworks and these kinds of prescriptions are always following the technology? We have these, large language models that essentially boil the entire internet. It's hard to think where they would go for more information than that. But at the same time, these regulations and these frameworks are always trailing. Do you, granted your first review of these initiatives, do you get a sense that the regulators and the standards organizations are looking at the kinds of AI models that might be developed in the future? Is there any understanding of what happens after large language models that would be especially impacted by these kinds of rules and frameworks?
I think that there's a little bit, but I also think this kind of goes back to the conversation we had a couple of weeks ago about the people who are like, put a pause on things versus that's the dumbest idea ever. Because I think that a lot of when people start thinking about the future, there's kind of a couple of models that tend to come up, and I'm not sure how tied any of them are to reality. There's the great big evil overlord future, for lack of a better term, which is that if we're not careful, everything that we do is going, we're going to end up being run by AI, and people are going to be killed off, and AI is the next generation of life, kind of science fiction thing. And and so that's kind of like one group of people, and they have a different viewpoint of what to be careful about and what to look out for. And then there's the we don't know what's coming next, so we can't even think about it group of people. And then somewhere in between, there's some people who are trying to think about what the next evolution is. But the thing is that for most of these things, it isn't like a clear straight line evolutionary path. For almost everything, that involves invention or innovation, someone makes some weird leap somewhere. So it's hard to tell what's going to be next. You can make some logical inferences of what the logical extensions are of what we're doing now. But in terms of like what the next new thing is going to be, or the next area that's going to really require a different way of thinking about it, that's really hard to do. I don't know if I answered that very well, but there's
No,
at
you
least
did.
a take on it.
Well, it's predicting the future, which is at best a fraud exercise. But I was reading that the CEO of the ChatGPT company basically said large language models are done. They can't continue to do them any longer for a host of reasons. One, they're unsustainable from an environmental perspective. They require a massive amount of computing power and consume enough electricity to power several small countries. But also because you do hit the wall in terms, as impossible it is to think, that there is such a thing as the whole internet. And once you've sort of scoured that, the possibilities for incremental knowledge from that same database become smaller and smaller. So
I would posit that you can still improve the way that you analyze and glean information from it.
I would agree.
Anyone else have any thoughts or comments?
Exclude all blogs from AI modeling. How about that?
All right, next slide. And if you'll pause there for a moment. I hope you learned a lot from our quick updates. If you're interested in finding out more about the DGC and its other activities, email me at dgc@myhealthdata.org. That email address is also on your screen.
Yeah, I mean, kailangan pero to